for the applicant IA 1 of 2019 Peru for the line below for the reasons assigned in the application duly supported by an applicant. Delay of 5 days in filing the appeal is confirmed in the result. IA 1 of 2019 is allowed. Appeal is admitted for hearing. Office is directed to secure the record of the family court. IA 1 of 20 shall be considered at the time of final hearing of the appeal. Learned counsel for the appellant has filed a memo seeking leave of dispute withdrawn the appeal. The aforesaid was taken on record in the appeal is dismissed as before. Both the appeals. 11.2. Right.
Number 30.
Yes, Monday.
Yes.
Monday. All right, Mr. Raj. All right. No. We are for us every day is same. So Monday is what? Monday is a holiday. Oh, acha, third. Yeah, all right. Learned senior Mr. Rajgopal, senior counsel for appellant praise for a short accommodation. List. Respondent. Praise for a short accommodation. List on 3rd of April 20. Yes.
The 14th.
Portion of the land we have taken over. Then other portion but we have not taken over, but in the sense that everything is taken. We have to take on. What is it going to be for that? What is the case that takes and so we have written the government that we will plan another day again and we said. After 2 days, even the balance.
You have heard what he said. You have heard, right? So you are getting some amount tomorrow. It's good, no? Good. What did he tell you? First tell. We will adjourn it. You want an adjournment? We will adjourn. What did he tell us? Please tell. You have understood. What did he say? No part. They have taken possession of the part of the land. Remaining half, they have to pay compensation to you, and they are seeking instructions from the government. Half of the amount of compensation will be paid to you tomorrow, and remaining amount within 2-3 days next week. So what is there to contest? Not. This is in your favor statement. There is nothing to contest.
Milord, forgive me, Milord. Serial number 14.
Senior counsel for the respondent, please for a short accommodation. List tomorrow. Right.
Great.
Week's time.
Not yet.
Huh? All right. Not the IA 1 of 2021 for the reasons assigned in the application form are duly supported by an affidavit. Delay of 169 days in filing the appeal is controlled in the result. IA 1 of 21 is allowed. Let the appeal be listed for orders on admission in the next week.
Sri Ajay Kumar here. Vijay here. Advocate. Ajay Kumar.
The site is not there. We are passing it over. Please wait for a while. You want adjournment? Huh? So it's within 5 minutes it will be called. Huh? You want an adjournment? Huh? Relax, relax.
We have passed.
We have passed over. Don't. Nothing is happening. Relax. Health first. Please relax. All right, all pass over. Pass over. What? Just let him be normal. Yes. No, Mr. Why do you seek, I mean, short adjournments and repeatedly keep on seeking adjournment? We will have it after summer vacation. There's no fun, right? The order, how many order sheets we must have signed? Then why then next week, then you will say it has just been signed, it is on the way. See, we don't know, Mr. We don't know about the sketch. We don't own the property. We do not know anything about. We are not going to be benefited. Repeatedly, how many times? 18/10/2022, thereafter 30th January 23, thereafter 9th of March 23. You please sit down. We are interacting 3 times. We have granted adjournment. So you please argue the case, right? Next date of hearing, please argue. We will not adjourn it on any other. When do you want? You tell us. Either you produce or argue. Last date also, we had told you to prepare the case and argue. You are again saying the same thing. 3 times it has been adjourned. How many times? Sir? It's not a fun. It requires a human effort. We are required to pass an order. She types it, we sign it. This stationery is required again. Just like you argue the case, it's better to argue. If you are not prepared, we will adjourn it. When do you want to argue? Be ready on that day. What's your name? This is the name, right? Learned counsel for the appellant. Though learned counsel for the appellant was granted adjournment on 9th of March 23 to prepare the case and argue the same. However, when the matter is called again, he prays for adjournment on the ground that he has not been able to prepare the case. Intelligence hearing is deferred. It is made clear that no further adjournment on any ground shall be granted as the matter has already been adjourned at the request of the appellant on 18/10/2022, 30th 1/2023, as well as on 9/3/2020. Now, to the date, what date you want? It will not be adjourned on that date. What date? You choose. It's on 12th of April 23. This order says no adjournment. Don't seek an adjournment on that day. That drawing has been signed and initial has not been done and he's running to the court. Don't. Please argue. He is admitted for hearing. Issue notice. This is directed to secure the record of the judgment.
Okay. Maria.
On
Malad Sahib, for the appeal in incident number
Appeal is
19 and 20, my
admitted for
lords.
issue notice. Or on IA1 of 23. Record. In the meanwhile, operation and effect of improved judgment and decree insofar as it pertains to dissolution of marriage shall remain stayed. What they are doing
Obligation,
here-
my lords.
What are you doing here? Come here if you want to sit with us. We will offer you a chair. Why are you standing here? Go there. Government advocate. Hey, Mr. Micus, at least you should take care of this, though. Huh? Tomorrow he will come here and ask us here on the dais. We understand that he's anxious, but he should not enter here. Yes. Paso. Nobody's there.
So, 22, the SK Mukandappa.
Huh? Yes. Yes. Yes.
The petitioners of the candidate for first standard. But the issue is not that the patient. The RCM regulator is up. The reservation. But the rules provides 50% reservation for horizontal. 50%. But pursuant to 2006, there was an amendment to there was an amendment in 2006. The amendment, thereafter, the government had issued certain circular regarding issuance of the certificates. The authorities which competent issues. But nowhere in respect of this horizontal reservation. What they say is gentlemen rule can be. These petitioners, we all have studied in rural area. Parents, the income is 8 lakh. They consider general merit good. For general merit rural candidates,
You are seeking admission to which course?
now we are completed. Now they say that say performa is not a prescribed.
Completely. Second year.
Yeah.
Then how? What is the cause of action available to you?
And what had happened was
You have appeared in common entrance test 23.
now that trying the reservation, horizontal reservation, now that the action can.
No, the prayer is that insist the petitioner to pro forma bulletin 1 for common entrance test. So you appeared in common entrance test?
No, to climb the reservation, kindly.
No, yeah, please answer this
I-
question. Have you appeared in this entrance?
Not yet, before filing case, I have to produce the certificate, to claim the reservation. That is the rule what we have to contemplate. Now what had happened in this.
Don't talk. Huh?
Sir, you are not eligible to appear, no? So you are not eligible to appear for 2000. Are you eligible for appear without the, assuming that we accept this? Are you eligible for this year? No. Specific question. 2023. Are you eligible for this test?
I am eligible,
Now you have completed 10+2.
but I have to make an because the cutoff date is there.
You have completed 12th standard.
I have not yet filed an application. But the reason is why, because this is the issue is this. An horizontal reservation for rural candidates, rural candidates. Whether the policy of that is the issue. Whether the policy of privilege is applicable. It is this court vote that is applicable. not eligible to apply the reservation.
You will go to Supreme Court. You will go to Supreme Court. Well, the question is, Mr. What is the cause of action which has accrued to you? And why this person is standing like with folded, this your client, ask him to sit down. Yes.
What had happened was.
No.
Like this, we have given
Huh?
the representation to the government and as the court respondent. But the state government also has, in fact, has written a letter to the annexed.
So when is the common entrance test will be held?
Not a date is not.
Then,
Cut-off date is given.
then
And coming actually,
you have not, the exact date of examination has not been declared. You have not appeared in the examination. What is the cause of action?
annexed P.
You are these petitioners are, let us, petitioners are students of second PUC. They will be completing their second PUC when?
No,
Now? March. When the examination will be held of second PUC? April. Result not declared. Then what this you want to appear in common interest test. Common interest test for admission to the Bachelor of Engineering course.
it was all professional.
Medical, both.
And all.
All right. So when is the examination going to be held? Common interest test.
Annexed envelope page 196.
190.
Information bulletin 1 common entrance test to 2023. So fifth is the April is the last date for submission of them.
So we have, yes, so please tell us what is your grievance? I mean, we haven't understood, we have not read it. This file was not sent to us, so we have not read it. So please tell us.
Page 2.
What is your grievance? The common interest test has not been held as yet. No date fixed. Now what is your grievance?
I am requesting the Lordship to kindly see page 255 annex P.
55. If I the unfairness, this is what
It's a 3/3/2023.
letter from
This is for the government to the court response after the. May read this. Reference to the aforesaid subject has been requested to correct the unfairness of the selection.
business. Shall we take it up tomorrow? We'll go through it. Better. You would like to be satisfied. What is it? Then we will hear you tomorrow. List tomorrow. Then it's
First matter. How much charges?
they have filed the objections. It's not listed for arguments. We will have to fix a date. That's why we passed it over. He told that date may be fixed, but we thought that we will fix a date. You will say I am not available on that date. That's why. Please tell a date of your choice. Not this Friday. Next week. Tuesday is a holiday. Thereafter. 5th April, 6th April. Right. SPP submits that objections have been filed. You will have to produce the record. Yes, detention. All right. Yes. All right. This, yes. We thought it's an order of detention. Submits that the statement of objection has been filed. List for hearing on. This is 2023 petition, and we are fixing it on 6th of April for final hearing. So you want that it should be heard today, order should be delivered to you right away, and we should permit you to take a procession from here to the jail. This is what you want, right? 23, this is the writ petition filed in the year 23. We are hearing it, whatever. Or you seek, I mean, we will say that it be listed before another bench then, right? If you want that. Then better that if somebody else can hear it, want it, all right. Mark the presence, let the petition be listed before a bench in which one of us, write my name, is not a member. We said no, 6th of April. No, you are saying 200 people are waiting. That means you are trying to say that it should be heard before 6th, right?
My intention was to justify the court the importance of this.
You are okay? List. We can't hear it before 6th of April. We are telling you. Fine. So let it be 2,000 persons or 20,000 persons. It doesn't matter. We have to decide the question of law, right? So don't try to say that there is 200 or what happens if 2 lakh people are involved. So the question of law will change. If 20 lakhs are involved, question of law will still, it will have a different order. 2 crores involved, it will have a different answer. No. So then you should realize, mister, you are relying on a decision of the Supreme Court, which according to you is in your favor. So it doesn't matter whether 200 or 20 crores people are involved. The law will bind us under Article 141 if we agree with your submission. So we are just trying to ask you, what is the need of telling that 200 people are suffering and not 20 crore people are suffering? What is the need? We are giving, we have agreed for early hearing. We are giving a date in the next week. 6th of April. This for final hearing on 6th of April 20. We have said it is listed for hearing. Likely to, so you would pray for time to report settlement. Learned counsel for parties jointly pray for adjournment in order to enable them to report settlement. List after 2 weeks. What an adjournment. When was the order passed? No, you will have to explain the delay, right? We asked, when was the order passed by learned single?
I apologize. But the order passed.
That you are not party, not represented.
We were at
Then what happened?
that point, the order which is in part note was taking note of two. Subsequently enactment. That is not at that point in time. The order passed.
Look, we are on the application for condonation of delay, not what was the opinion of your officer and BDA, what is not
Taken by the appeal. The matter going on Thereafter, once the decision was taken to challenge the order,
It was decision taken.
14/7/2021.
Why?
Uh,
Para
that's it.
additional affidavit.
Additionally,
The judgment, you have not referred to when was the judgment was delivered, which came to your notice. Nothing. When state government directed, called upon commissioner to look into the matter, when Government of Karnataka noticed that in several cases BDA
Even that is under section 27 also writ is allowed, not only on 24. So you was on 27 of the BDA Act also writ is allowed, not only on 24. Then you would have taken decision, no? Why you have waited for the Supreme Court? No, 24. No, order is both on 27 also and 24 also, no? Huh? Both. No, you are saying that. No, you are saying that law has changed by virtue of the Supreme Court order. Hence, we could not take the decision. That is not correct. 27 lapsing is declared by under 27.
So you realize, Mr., that there is no explanation for inordinate delay. We are liberal in condonation of delay, but there has to be an explanation. The order has not been only passed on 24/2, but it has been said that under section 27 of the Act, the scheme has lapsed. So you should have at least challenged that order to that extent, leaving aside 24/2, that it has not lapsed under 24 and 27. And thereafter also no dates, right, sir? How many years delay?
but there is no.
1391 days. And there is no explanation. Delay, obviously, that's why.
Matter was not taken as a. Noticing all these issues we have taken.
What happened, sir? 24/3/2016 order was passed by Learned Single. You were a party to the petition. It's not your case that you were not, did not have any notice. Your counsel was present, he was heard. Then what did you do till 2021? There has to be some explanation, right? Even if expression sufficient cause is required to be construed literally correct. But there has to be an explanation. What did you do from 23/4/2016 till 10/8/21? Please tell us.
Since 30th/5/2016, advocate sends them certified copy on letter. 30th May 2016.
30th May 2016, you received the copy. Thereafter, what did you do? Where is the OP? How did you come to a conclusion? Like, absolutely, this delay has to be explained, right? You cannot, without producing any opinion, any this thing, you cannot say that. What have you done for 5 years? Please tell. But unfortunately, that's all. That shows the carelessness with which you handle the litigation, right? I discussed with are concerned with what was at that time prevalent. Why? We are concerned with the sufficient cause. You tell us, you are asking simple questions, answer. What did you do? 30th for 23 for 2016 order passed by learned single judge. 30th May 2016, you received the copy. What did you do thereafter? Tell from your application itself if there is any explanation. When did the council give an opinion? Who, when commissioner said, then who told you that it is wrong? Nothing. No particulars. How can we just rely on your ipse dixit, whatever? And there's no explanation in the first place.
It's also single judge has held that award is not first position. Not even one word also in appeal. No, sir, grounds also you have not stated that we have taken the, in grounds of appeal also you have not stated that we have taken the position, award is passed, land is vested with the government, learned single judge is wrong, nothing of that sort. You have said that BTM layout is substantially implemented, 24-2 has no application. Even otherwise on merits also nothing, you have not stated anything in the appeal also.
Oh, this BTM, this is BTM 6th stage. So we have decided bunch of topics, right? BTM.
Yes.
What has been at, what has been in, right?
BTM bench is confirmed, I think. Same.
You should tell us, right? It's not that if you won't tell us, we won't find out.
Ask to explain the delay. That part.
But you should have told us that even otherwise on merits, it is, this court has decided against.
Yeah.
Even otherwise delays control, you lose, right? We are bound by our judgment as of February. Heard on IA. Heard on IA 2 of 1 of 2022, an application seeking condonation of delay of 139 days in filing the appeal. We have heard learned counsel for the parties at length. Appeal has been filed against an order dated 23rd April 2016, passed by the single judge, by which writ petition preferred by the respondent has been allowed review on the ground that the scheme framed by the Bangalore Development Authority in respect of BTM 6th stage. Scheme framed by the scheme, namely BTM, whatever BTM,
Yes.
BTM 6th stage has lapsed under section 27 of the Bangalore Development Authority, as well as under section 24 within bracket 2 of 2013. What is the 2013 land acquisition? Fulfillment. So, Admittedly, the copy of the order was supplied to the Bangalore Development Authority by its council on 30th/5/2016. The paragraph, the authority has filed the application for continuation of delay of 319 days in filing the appeal. Full stop. Thereafter, an additional affidavit has also been filed. However, explanation what the name has been furnished in the additional affidavit as well. The delay of 319 days has in filing the appeal has not at all been explained. Paragraph. Even otherwise, bench of this court by the order dated, even otherwise the bench of this court by judgment dated 1/2023 passed in WA number dash WA number WA number HSR layout, Mr.
BTM layout.
BTM layout. In WP number this is HSR layout, right? BTM. This is the HSR layout, right? We have passed this BTM. The WP number by order dated, what date? Judgment dated. Judgment dated dash, right? The WP number 36667 part 2011 has already had that the scheme, namely BTM 6 stage has lapsed. Full stop for the aforementioned reasons. No sufficient cause for condonation of delay in filing an alternate delay of 139 days in filing the appeal is made out accordingly. Delay in filing. Accordingly, IA so and so of 2022 is dismissed. WA 895 part 2021 is also dismissed. Next, Mr. What this is what first stage. There is no judgment. What is it?
The order is passed purely
When
order dated. Yeah, yeah.
15 December. What have you done?
Here I am not filed yet. Yeah, I have it.
Need counsel for the appellant based on is granted 2 weeks time to enable him to file a better affidavit in support of application for condonation of delay, namely IA 2 of 20.
Twenty-one.
All right, we'll see. You will issue notice, Mr. Ashok. Learned senior counsel for the petition. Notice on behalf of 1 and 2, right? 1 and 2. 1 and 2 is accepted by Mr. Lakshmi Narayan, learned additional government advocate. Mr. So and so, what's your name, Mr. Learned counsel undertakes to supply a copy of memo petition. A recopy of rate petition of the registers to Mr. Ramesh. NK Ramesh, learned counsel who represents respondent number 3. Then pre-regulatory committee and all that. Mr. This thing, N.K. Ramesh and Mr. Om Kumar Learned Council, who appear for respondent number 3 and 4, office is directed to reflect their name. Then 5 and 6. Mr. Letter 6, 5, you write to Mr. Om Kumar and Mr. Shanti Bhushan, Learned Deputy Solicitor General of India, who appear for respondent 3, 4, and 5. Right, office is directed to reflect their name as counsels, issue notice to respondent 6 to 9.
Further hearing. 23, the Mithun GA.
They included section 498A, the second line. We were not required to mention the principle of 498 for the case of assault. They refer to section 498A in the second complaint as well. Therefore, the husband has put the one side. See that the second required was apart from other section, inclusion of section 498A amounts to double jeopardy. Therefore, the second required is charged with state.
That is not the ground on which the decree for divorce has been granted. double jeopardy, etc. That is not the ground on which you are trying to tell us. I mean, yesterday we have heard you for 1 hour.
I'm only mentioning the.
So what you are arguing, at least speaking for myself, I don't know what you are arguing. Double jeopardy, that is not the ground on which decree of divorce has been granted to respondent.
That is not the ground, because I stated, I've taken that.
Subsequent FIR he has filed against you. That is not the ground on which he has sought divorce.
That district office. I filed an district office.
That's what we are trying to tell you, Mr. That subsequent FIRs may not have a bearing. The family court has not granted decree on subsequent FIRs.
Of course not.
So we are considering his petition, whether on his petition family court has rightly granted the decree of divorce. Subsequently, you may have filed 15 FIRs and he may have been convicted in all the cases. That doesn't make any difference. Doesn't make any difference. We have to consider whether on the basis of material available on record, the ground of cruelty is made out clear and simple.
Therefore, another factor that I cover is why I also keep talking. Whatever FIR was that was pending at the time of family court case, decree into the past. He said cases are still in pending of trial. There is not in the trial. That is one aspect I was looking at. Now that's the idea. My submission that the maximum cruelty as I is both incidents with the analysis against the fight, as well as the incidents of medical attention that was required to state that that aspect. Now, it is my submission that has relied heavily on the fact that I have not disputed the case. I have not disputed anything in the negative while examining the aspect. And on this basis, and also the basis of the fact that there is an unsubstantiated here, and there is a plea report that is being filed, and there are criminal cases that is being filed against him. Considering all of these facts, the court came to conclusion that there is a cruelty committed by. Now, whether this suffices to pull that the husband has cruelty, and whether the tendency of criminal cases would amount to consideration of cruelty and consideration of the B report.
No, if on the basis of complaint made by you, he has been arrested and put behind the bars, it matters. That is the question.
That is why I also mentioned in
Like you are said, you are instrumental in sending your husband to jail, and you will say that it doesn't matter. I have a right to file complaints against him.
Whether acquittal or whether it's conviction is
He was put in jail, right? He was arrested.
fact that
He was arrested. The fact is that he was arrested.
case of offenses is that was arrested. And on the second occasion in 2015 as well, when there was an assault against the right, and the son, there was he was taken from the house in all the years. And also proves that it is to corroborate with the fact that the fact that I am just submitting that when considering the whole picture into consideration, the cases that were filed at the time of the mechanism petition. Actually, subsequently, there is an instance of a thought medical record had been reviewed, and he was taken up from the house and along with and the neighbor has called the police application. Therefore, the iota of doubt that there may be an instance of harassment by the wife may not be a consideration at that point. Right? In the mood of my this just has made certain allegations that are made by allegations that were made against by their for doing instance of doing is exactly the gathering of case certain instances in 1989 despite the
Those were facts of that case, right? Question of validity has to be determined in the facts of each case. Para 4, did you not go to attend his brother's wedding? Huh?
how facts lies and how the
May not be relevant, right?
it's not
So,
relevant.
if any principle of law has been laid down, please read it. Facts,
I
reality will differ. I mean, if unless you are saying that it's identical, para 4 reality has similar allegations. What will bind us is the ratio of it,
I'm just trying to say
not facts. What she didn't go to attend his brother's marriage because she was pregnant. That is either you are not pregnant, you did not go to attend. Then that's irrelevant.
as having
Yes.
by I would also think quite right. Nine. I wouldn't go into five, but even otherwise, apart from the wooden treatment, I would, but R9. Even otherwise, apart from the wooden statement made by there was no intent of the allegation. The applicant did not examine the author of the maybe even one extent application, but they are telling that this one, the court did not believe how they feel. Apart from his oral statement, there is nothing to support his facts, and the thing has been made by you, by way of filing an application as well as other aspect of law subsequent in this case, the children is filed 5 years, has been here, retired by honorable law court, stated paragraph 13, as 13.
Says that he has filed criminal case. She has filed criminal case. So, kind of criminal cases among two very which paragraph? No. Yes.
Yeah, second judgment is what in an allegation made to an act of that by and in front of people and political relations as well as in front of over the honorable get back that there is not such evidence for that. Which is in respect of I think the last 5 lines as very
Yes.
last 2 lines, the tenor of well, which that in every case, the middle case filed by one party, I likely to be for cannot be everything all the that's what in the behavior regarding it's long with contact, rejected to process of filing the FIR. As of the date of petition, count that was taken is the respect to the incident that he alleged. The pendant of is given the doctor and the way of evidence documents that have been produced. So as on the date of the petition, by incident of marriage and not with respect to or is subject to the threat of the pending to a case that came to filed subsequently when he has not amended the petition and taken that as a ground for may not and the fact that the pending is the still pending may not be the consideration of the evidence or material necessary for granting reviews on the basis of those. Because the next judgment page 16 of the relation. So, not to send the fact what I mentioned last time. However, the we are recording of completing the repair.
Which paragraph you are reading? Paragraph.
I am using it. Paragraph.
Which paragraph you?
Paragraph 13.
Paragraph 13. Yes.
Second case, the prosecution launched by the respondent against appellant in the section 290A of IPC, making serious allegations in which the appellant had undergone trial, which ultimately resulted in the prosecution under section 290A IPC not only acted as in the further operation made that allegations of serious nature are leveled against each other. Case settled with the appellant duty has been established. Here is where the respondent valid before that is five. Yeah, sure. Even at
Yes.
First judgment was the other aspect is I would like to refer to is
Little fast. Conclude already yesterday we have heard. Yeah, yesterday you have told that.
With that, the one will go rephrase the fact that the respondent doesn't prove or disprove the fact that not he has subjective. I think all of these facts, the allegations of cruelty and has not been by the or the allegation of people by all of Supreme Court he takes as a allegation. Right, believe the fact the fact by total not
Sir.
Sit down.
Petitioner has been subjected to blame midnight period. And has indeed succeeded. Appealing to the contents of the multiple trial, that he has indeed made out a case. Enabled the honorable trial court to sit in the armchair to experience that excruciating moments the husband has experienced through this matrimonial life. I say has indeed considered it and as well the evidence that was available on record. So as to come to a proper and legal conclusion, so as to be a sound reasoning, judicious reasoning, to say that yes, the husband cannot be expected to live anymore with his spouse. And it is also given a finding that it is not the normal parent. It amounts to cruelty. It has indeed suffered. But the epicenter of the allegation is what why it makes it against the husband. It's pertaining to the adultery. So it is suspicion. Here, suspicion will have it has been on to tormenting the husband by filing making false various proceedings before various court subjecting the husband for serious in the family court. The statement of evidence what he has made competent the allegations of guilty suffered by the right the hands of the epicenter of these here also there are self-contradictory conclusions what they may make. One judge said so to demonstrate, we had an opportunity But the evidence part of the allegations had been contemporaneously in the domestic violence. She had this state after the filing of divorce.
In this case, that is in this case that you don't rely on my evidence. You have to establish your allegations by substantiating your evidence. Reality. Please take us to what you have pleaded and how you have proved that. Then we'll come to the what statements he has made in the statement of objections.
Answering the husband had this petition because he said that he certificate thereafter, but she filed a case for it. And making the very same allegations, she made in the statement of it. And that was the process of India for the family. He has taken a chance to test the allegations are giving the trial involved in family. The very same allegation the proceedings before the court. It's same allegation. Case has been registered. The person complained that seeing some knowledge. Also, the same allegation. Also, the later complaint she filed when the case was heard finally. She filed against a one person to examine putting the FIR and complaint. Here, 2015. But even in that regard, she has led it. So she has brought to the notice of the family court for the syndicated it. And indeed, the family court has considered all this. Now, the vital actions she has gained by being cross-examined. That regard,
So we take it that you have not led any evidence for cruelty, you are relying on our cross-examination, correct? My lord has asked you to show what are the allegations of cruelty made in the petition, what is the evidence led by you? So you have not led any evidence, you are relying on her cross-examination, correct? Because you are referring to it. No. You should refer to the evidence led by you to prove cruelty, right? You have filed a petition. You cannot rely on her to prove your case. Huh? So, what are the elements of cruelty? Tell us briefly, and what is the evidence you have led? What have you said in your deposition?
Argument by expressing the parties, the comprehension of the
No, but we think law remains the same, that the burden is on the person who who has filed the petition, like the ground, the burden is on you to prove the ground of cruelty by reading evidence.
They read the petition.
Please,
That was summarize.
briefly, what are the 1, 2, 3, 4, 5? These are the allegations of cruelty. What have you said in your evidence? What then you can then advert to her evidence statement? Briefly, what have you? What is cruelty? What she has done?
The the mother of the husband with derogatory remarks. And he is the husband. He is the God incarnate. He worships. And when she is the fully accused, derogatory remarks, quite natural that the son would have a great amount of, or rather perceive a great amount of agony, and his mother is being abused. That he has made it very clear to be permitted. Is one act. Otherwise, the parent mother, she was gets to be a homemaker. That means she has some responsibility towards the husband. At least to him in preparing himself to going for office, of his breakfast, of his lunch. He totally agreed, he doesn't prepare food. And for a few paucity of time, he has requested her to wash his clothes or to iron his clothes, and she throws it from the balcony to the street. It is requested for. It's very strong stress on the husband to manage him, both for the family and for his household. Then why is cooperating for this household? It is one aspect. It is not a matter of temperament. It is her total disregard the duty which she is going to towards the husband. It's the reason. Not say that they have come to her just to iron his clothes, to prepare food, and she abstains from all these duties as well. It is one. The relatives of husband come home. She is either avoiding to be at home and to attend to them, or she doesn't even speak in a pretty manner to them, or rather would insult in an unfriendly manner in front of relatives or in front of the friends who attend to see the house. And even she one on one occasion she was slapped him in front of his house. So these aspects were rather insult the husband.
Yes, sir.
Maybe now and then she intimidated the husband that I am going to file a complaint. I am going to file a case under domestic. She said it to not listen. So these are the intimidations which she was frequently making to the husband. But in 2002, he had taken refuge for the honorable family. So that things would settle for some time at least, and cohabitation would be soon. But the parents of the wife persuaded the husband that they are going to discipline. Stay back. That's the reason why The evidence is that regard is based on 742 of they produced that. Even in fact, I also produced that. The documents. Year 2007. Yes. I think this is 488 not like before I he makes a statement 10 days later before the police. She makes a statement that there was a panchayat held with the parents, parties, and the one doctor who is examined as RWQ by her before. Therefore, things have been reconciled between the parties, and she wants to withdraw that complaint, and that can be closed. She gives a letter that they read to the police, and it has been recorded. After evidence, of evidence to say that there was a contact date in the state, the presence of the respective parents of the party, and in the presence of the. She gives a statement that is recorded. The report is filed saying that ತಪ್ಪು ತಿಳುವಳಿಕೆಯಿಂದ ಈ ಪ್ರಕರಣವನ್ನು ನೀಡಲಾಗಿದೆ ಈ ಪ್ರಕರಣ misconception complaint has been filed, so therefore
They have to live together.
they are harming for a short period. Once again, video which was nonchalant rather persuaded or rather provoked the husband. They were to wear the fidelity of the hand quite this kind of. Our conduct is those things dying to the ground or towards the person. She has done this both to the mother of the husband and he evidence of the mother in this regard. She died. He was arrested in bars. That party has given for a month. She was suffering from cancer. And she behaved, she pretends by an ostentatious conduct that she doesn't know that her mother-in-law is suffering and that she is taking into the but she is being prosecuted. And when she cross-examined the petitioner, he suggests that your mother therefore, he is pretending as if he doesn't know that the mother-in-law is suffering. Elderly member in the family and behaving oblivious about the which she is suffering, and she abstains from giving any care for the husband for his mother. Also,
Mother was staying in native place, no?
later, in fact, she was staying with the family only. His sister. And she was also admitted to hospital. When she wished that she wants to breath her last in her dating place, was discharged from hospital and taken to dating. She breathed her last in few days. Not even attended dinner. Matrimonial home with the children, she goes away from the family. Examining the father to take the children to have some Quebec's in a cross exam. But the once has been subjected to discomfort, insult, and false allegations, even as on the date of approaching the police. Here, admittedly, will not there is obviously the ground floor in the very same building here. And obviously, the staff would be there, and in front of the staff, all these things sometimes happen. The screaming, the money. He is not bothered about injuring the sweat in front of his own staff. He knows that dignity before the staff in his own home. He is the proprietor of carries on his own business for installing and commissioning some equipment for mobile towers. And he keeps on traveling sometimes. This behavior of the wife has caused to people is has produced it on. Okay. For the police. The estimates for the criminals, but even the order of the we will be with regard to some photograph, CD, camera. Well, so these are the photographs we demonstrate we working and moving with the books. So on so on. She admits in the honorable family court has not considered all those. The family court felt and expressed it orally that such matters considered the maintenance has to be decided to the manager. Water. So, clearly demonstrate there were false allegations against. Even much before these cases could be decided, he took a chance to put to test all these allegations which have been made for the family. But he was unable to. Very absurd. None of our relatives stood side saying that yes, but not her sister. Right? Has been all these stories, what she is. And in the process of that, even the period earlier to the fisherman to say that the process of happening between the husband and wife, or the suspicion what And it writes since 2007. Teaching that. That's what. He says in the cross examination very clearly that not the facts. She admits in here and now. But she admits that she is not affected by any cure in the spell. Can take a large because there is no kind of problem with the DNA. She is making all the matrimonial. He wants to be the affluent class of people. She wants to be better.
This evidence. Not referring to this evidence.
Refer your evidence.
Okay.
Price is yours.
You are not
Once
referring
again,
to
third-
your evidence. You are again banking upon what you have said in
Third
cross
time we are saying that you are required to prove your case based on your pleading and your evidence. That is his case. Family court has committed error in believing your evidence or your admission instead of you are required to prove your case on your own. Burden is on you.
What have you said in your evidence? What?
Facts. That produce this. And 28
Slapped you in front of your friend. Have you examined him? That your friend to prove that you were slapped in his presence by the appellant? Who else have you have examined yourself only? All.
I have examined myself. It's called examining.
Your allegation is that he used to insult the family members and the friends other than you, whom you have examined. To substantiate those allegations. Other family members said, mother,
Friend of husband, if the wife said, your sister is on.
we don't know, we are asking.
That's fine.
You have said that he used to insult them. He never taken care of the mother. Other family members have stated in the pleading. He used to insult in front of the colleagues. Have you examined? Have you examined them? Is the question mark.
And staff of the
What has he stated?
because he gave in derogation of the duty towards he has been not attending to household, like preparing food or washing his clothes or ironing his clothes, so assisting in managing both family. He is after all earning for the welfare of the members of his family, but he is not being given any kind of assistance. And sometimes he has to go upstate. And his father Yeah, spur comes sometimes late in the night, when they have to go to some suburban area, but late in the night.
Read from the evidence, I mean, this, please read from the evidence, what
Yes,
all orally you are telling us, like a story.
Millard, I wanted to save time, sir. There is some paragraph 4 in this. Can
Don't read entire thing. It is a reiteration of the petition, but point out from the affidavit. Where are the allegations? What you have specifically pleaded? You point out this. Instead of reading everything, 29 paragraphs, then additional affidavit. Point out where so that we mark those paragraphs.
paragraph 5, but it is not to the sort of this life. Take care of this. Okay. Take care of. So be. But very bad.
Correct. And for accident.
Even 12 I made the road traffic accident. Yeah. On the but the always demanding me prominently with her friends. Were always in habit of expect the demand. He would create a parallel. But the main child, you will get because already of this thing, but in the interest of it was more you. Then the part of this one is some but it was 6 days. After respondent has usually takes full responsibility of the good.
Those are same allegations. Thereafter, in 2006, another child has been born. From 2000, you are reading, from 2006, another child is born. So these are the general allegations. Come to para 18.
Very right. That's why I think that there. That's why it was mediated itself again. For that submit on 8 get work to the people and you can't. Get to value. And the responded quite a long something that the video of the activity. He was celebrated because one good and not be responsible. And I, if I go to getting suspected. Twenty 27. Oh, one day. So, very far. The second to that, Neglect. Divorce.
Children are in the custody of. Children in whose custody?
Then the same thing. ಅಪ್ಪ ಎಲ್ಲ ಒಂದು
English.
ಮದರ್ಸ್ ಕಸ್ಟಡಿ
Yes.
ಅದುವೇ ಇಪ್ಪತ್ತಾರು.
Yes.
This it's stated that mother is on the way to prove that she is but it's not it's not study. It's stated that there is no evidence. It's not the evidence for the state. That's right. That proposition that we to say that the basically for negative evidence will be on the it's not. We put the statement that it's not the evidence.
When did your mother die? Did it come? We didn't.
Petition and read. Yes, sir. The education part. And with regard to the alleged, what was stated in my toxic candidate, I suggested the alleged is up to by elected. May I read that? From both lines. In my book. Ready? But They were giving.
That nobody is disputing, sir. That you need not read. You are required to read page 19. Where you are denied that there is no such relation with Nandini. That nobody is disputing where you are residing. Whether you resided in like Mahalakshmi layout or Prakash Nagar, that is not relevant. No? You start reading 23 pages, then it will be 5:30. Read relevant one and point out us so that that everything that way I noted. Yes.
Nothing so material. He has said there is his own case, the cross examination.
Anything admitted by R1,
Yes.
don't read the entire thing. You please point out that.
I have made marking.
Please show that. Please show that.
Page number 13, cross examination conducted on 5/12/2000.
Registered against the petition. That.
Very good question.
Huh.
What we will get is the what
Line.
But I think by the date number is a separate topic. Since I separate as fourth page. Then recorded 2015. petitions that he is not grieved by any conduct of the husband. That is right about 3 cases. First, you are to take page 9 of the draft. Let me on 22nd. Page number 11. Last period.
Page number? Page number 11.
Page number 11.
Page number.
So like and next one. Elected on 28 January 2015. But page of since it doesn't carry page number. Last. It starts from actually. Actually, no quarrel between myself. Page number. Page. Is very same process than it is. Elected on 28 January 2015. First two line. Which he was asked. Which he has made various things. Question was and you felt that it is possible for you to believe. Yeah, so yeah. I never felt that it is possible for me.
Read the previous page, 4-5 lines. And I questioned the petitioner regarding his relationship with Nandini. You have just read, no? Just previous paragraph. No, when I questioned the petitioner regarding below that, below 4-5 lines. Same thing, sir. When never question the Nandini regarding the allegation you read, no? Please read that entire paragraph.
It is also suggested that the Modi
All right. That is right. Anything else?
The next page,
What is your point?
I have a page that. The process-
So, correct. You wanted to say we are ready. We already pointed out. Be fast. Please check fast.
Page number 14, December 2013. That she still intends to file one more complaint against the express. Last. December 2013. Page number 14.
We are ready. Yes, Nandini.
This fight against the.
Documents you have produced.
Not the complaint against the. Down. Yes, sir. What we are.
Everything, no? Most entire cross examination you read.
The daughter of sister of the petitioner by name Komal and Upravati about the equivalent Komal of regarding the case of the marriage. He said, told the temple, Komal has not told the marriage. Equivalent Komal he said, yes, yes, yes. And
Because subsequently it was allowed, no? The petition was allowed. That is the reason it is. Your petition was allowed by the family court.
not by public, the petitioner.
All right, all right.
That the honorable magistrate, the London magistrate, it's understanding the case you are bringing back. Has made it so judgment. It has not been the magistrate has not elicited the findings and said. It's not. Now, since the same document, they have to test it again in a particular proceedings for quota. Again, they cannot ask for the indulgence. Test once again in CBA before the family court. Their intention to use all these documents, state is on seek for a writing on CBA. Now, the proceeding has given a writing. It is that they have given criminal appeal, which is waiting for the decision statement. But they have stated all these suspects before the decision statement. They have sought for intelligence of something about first of it. And people who just incredible. The photographs they want to produce now. I have one of 2022. It's like what? Yeah. Some evidence. Say that photographs to establish. I don't think anyone is. Then respect. They admit by witness statement that the mother of the baby the talking to that she says, when she was
Yes, sir.
just check it. By deciding the actual evidence by family. If there are any cases today, but we don't have to wait for this medical.
Mark the paragraphs and give later, no problem. Because we have spent entire half day here, yesterday 1.5 hours.
Yes, sir. And market instead.
Yeah, give to court officer. Can give later, no problem. Anything want to that's all.
That's all.
Finish in 2 minutes. 2 minutes.
Especially in the.
This date is given out. I don't read that. Get that the daughter-in-law coming up. Don't see the context of the setting up for the wife to meet for them to meet, take benefit of that. Here they stated the fact that mother passed away. Evidence that I mean,
Arguments is reserved for delivery of judgment. Reserved for judgment.
Yes.
That is.
Other matter, number 9. Check Madhupati. Contribute.
The partner case, we thought we will finish that and we'll take it up. Passover means this is a Passover round. First round, where were you, madam? Ah. I think you were there. Mr. Lakshmi Narayan. What Passover meant? This is a Passover case only. 3 o'clock, madam. 3 o'clock. At 3 o'clock at as per your convenience. Mr. Parindra, what to do? She's asking for a passover. We don't know. We had a partnered matter, so we thought that we would finish it and take it up. We didn't realize it will ground of cruelty. We will argue for 2.5 hours. We have two sets of advocates in MFS. One who finished the argument in less than 5 minutes, we have to tell them, please argue. The other one was this time. We had to tell them, please stop. I mean, what? Today also the other council took 1 hour. So we thought that we'll finish it off and then take. Now she says, Passover. Passover means what? We on tomorrow. Tomorrow. Madam, this can't be like this, right? You cannot tell the court that at 3 o'clock, 2:30, 4:30, this can't be, right? You knew that it will be, we will take it up in Passover round. You knew, your senior knew, she was here, she has gone away. All this is visible to us, right? We have also been there for about 20 years. I have practiced. My father also practiced. So we understand, right? Sitting here when some other case is going on, then when the case is called going out. It's all understandable, right? Could have said there also that I have, the senior is busy in court, or you should have been there, right? Yes, madam. Giri. Fine. So we were trying to tell her that you could have been here and told the other court that you are busy in court hall too. You say that it's covered by the judge. Can you tell us some facts? Please, just facts briefly. You have given us synopsis also, right?
The Act says and came on 2020. They issued a guideline for 21/8/2021.
So let us this thing. Your this thing inspection. My inspection on 12/7/22. Thereafter.
Regarding
CCTV and Google timeline. And then show cause notice annexure H
Yes.
was issued to you. Then 1912, then you opportunity of hearing
It was given,
on 23/12
but the hearing was given
by the hearing committee.
Yes.
And thereafter an order has been passed on 1/2/2023 imposing the penalty of 2.75 crores. Then you filed an appeal and the then this appeal was heard by the same persons that you told. And in appeal also they were there.
Yes.
Who else apart from these two people in the committee? Ah.
There is answer for all the many.
Order dated
17th of March 2023. 55. Page 117. Denying me permission to order students.
17. Ah.
Interesting part is the last date of admission was 2023. After they finished all, the last date was they rejected payment. One is that they don't have the power to delegate to a hearing committee. Here it places it before the court. The hearing committee pay one, two, three,
So right, the submissions which you have made is that like, that the hearing committee has heard you, therefore the person who has heard you has to pass an order, and that you are relying on a division bench judgment. Secondly, is you are saying that requirement of CCTV footage and Google timing has been introduced on 17/8, 6 months on 17/2022. That requirement cannot apply with retrospective effect. This what
appeal also now is rejected on the basis. The same two members who heard me originally are part of the hearing committee in appeal who place their recommendation.
where have you said so?
Where's the it's
Petition paragraph.
That's 16. First two members only before my appeal and para 16. Your letting the appeal. I've taken two members in the amendment. And para 20.
You have filed a thing amended petition also.
There is an amendment. Para 24A.
Yes, we have got it. 24A.
24A regarding the city member being. Yeah, please. Okay,
Ah.
The last of the order also is based on a hearing, just conducted by somebody else and the court takes.
Where is the initial order page?
But the initial order we allowed.
1st of February.
The page 67.
Yes.
That page 68, they say opportunity of hearing was granted. Opportunity of hearing was given to the faculty to present and make this before the designated hearing committee of 9 months and 10 months.
Would consist of whom?
The board, the act, if president and eight,
So president and 8 members have heard you. Have heard you.
Oh, clearly, after your lordships are recorded, you have to keep they have and Dr. Anitra, they are not even members of the board.
They are not members.
They are not members.
They have a power of delegation, right?
They have the board is still,
Like 25 or 10 or something.
they have no. But if you want to see the act,
All right. So you have to then. This is the order, and where is the order passed in appeal?
in appeal, your lordships get the page 103. There is the decision of PAS for the chairman. PAS constituted a committee to hear the appeal. Getting the request for clarification.
Where is it? Where did you? Yes.
At second paragraph, after the subject of that, the appeal of this
Yes.
against the decision of the chairman.
This is appeal under which provision?
24. 24 says
24(3).
that if any decision of any decision, the board took the decision to impose penalty on me.
So you are saying that it's an appeal under section 23.
That's the only provision which I can find, but they pass an order.
No, why we are asking, Kanindra, in what case it was argued that it only refers to decision of autonomous board under 24(2), not an this thing. All right. So you filed an appeal before the commission under 24(3).
There's no provision mentioned.
It's your case, right? We take it that you have filed under 24(3) before the commission. All right. So so your case is that you filed an appeal under 24(3) before the commission, and that has been dismissed.
I've also the hearing committee. Who had actually.
Apart from 2 members, there were other members. Appeal also.
Also.
Where is that? Where have you said it? 20.
Para 24 AM.
So then it has to succeed on this very ground then. Madam, what?
Capital A, page 24.
Capital A. Oh,
It is pertinent to mention the hearing committee consists of they are identified.
no, that the appeal was also heard by same
Same
member.
word, in fact,
Where, which paragraph?
page 60, paragraph 60.
Paragraph.
The petitioner as well as the faculty members appeared before the hearing committee of 9. The hearing committee was headed by 2 members of the student of the curriculum area.
That we have understood, right? That you were heard by a hearing committee and order was passed.
Yes.
And then you preferred an appeal under 24. Your contention is that that appeal was also heard by the members of the. That is not there in para 16.
16 is regarding the original order. 24 is
24A is non-application of mind and this thing all. But this is heard by
16 would be very simple.
where?
24 capital A, which is the hearing committee consists of 2 members of the Court of Karnataka CH-2. I will have forward. As an order, that is good. My own order is 1623. By same order, that is very serious. At 24 also it is same. It's up to 24. Page, para 20. Appeal before the appellate hearing committee of 24 to 50 over. CISM has designated the hearing committee of the same hearing committee which has heard the petition, as well as the faculty members of 9 resulting in the pass of the include order, the appeal was headed in the same committee. That penalty at section has to go.
This round. Yes, madam, is it correct? What do you say 24? No, you only tell us. So like, please. So if you will agree that if it has been heard by the very same two members, it can't be done. Like they don't. No. Okay, you leave it to us. You leave it to us, data and all that. But you tell us you have read para 24, right? So what is your response? So whether that you say that these two people were not there for consideration of the appeal, they have not heard it, then end of the matter. Then we will go to the other points. If these persons have considered, it can't be against your decision, appeal will not lie to you only. Can't be right. No. We don't. No, we don't know. Please see para 24. Please read what is stated there. First, understand what instructions have to be sought. Now, please, para 24, please read. So, like, what his submission is that the same members have heard the appeal also. That is so, it can't be like this. Against their this thing, no. If they have, we got it. I mean, you are saying is that you are saying that they have not passed an order, but nonetheless, they have just a minute, they have after hearing him, you said that your cases, you have power to delegate under the provisions of the act. The board can delegate the power. The board has delegated the power to a hearing committee. Correct. So if those two members have heard him and made a recommendation one way or the other, maybe in his favor, against him, whatever. And on the basis of those recommendations, an impugned order is passed, which is subjected to an appeal. The appeal cannot be heard by the very same members who at the first instance made the recommendation. Because why? Because they have a preconceived notion about, because they have already given an opinion in the form of a recommendation that he has not complied with certain requirements. So how a person who is already formed an opinion can hear an appeal? A recommendation, madam, recommendation. No, first of all, just a bit. First of all, you ascertain whether these two persons, this thing heard the appeal, number one, and then you justify that they could have heard it, right? That's your argument. All right. We thought that you will concede that they can't hear, but all right, we will decide it. Huh?
There is one more order we can tell it.
No, like see, Mr. Padivra, you have preferred an appeal, and if we accept your contention, then the
Order passed.
there is no remedy of an appeal.
Against this law, the denial of it is very. One person here.
No, that's a different aspect. Now, what you have altogether brought a new aspect. Say that they constituted a hearing committee of two persons, right? That committee heard you and made a recommendation. Based on their recommendation, the president agreed and passed the order. Against that very order, you filed an appeal. That appeal was also heard by those members, and they made a recommendation. Now, her contention is that these two persons are competent to make because they only make recommendation. They don't decide. So therefore, they are qualified to hear you at the first instance as well as in appeal. That is the submission, right? That we will deal with. That how this we will deal with, pass an order and decide that issue. So if that is so, and if you are succeeding on that very ground, then what is the other ground? The other order is
The other order.
Deficiency and deny you permission to admit students. You see, madam, this also that the what all the board has passed an order. Board means not the president alone, but the president as well as 8 members who have been defined under the act, right? So all of them have passed an order, but there is no appeal against that order.
I mean, this was I think we have 28 laws, then again, I have to go to HAS.
Ah.
This is a now where
If there is an alternative remedy of an appeal,
this order, what it says, within the act of 28 itself.
no, that you will have to address that. No appeal lies against that order under, you can argue, or we are just asking you whether if there is an appeal, then we will relegate you to the remedy of. Because in one case, we are dealing with this question, whether against an order of the commission and appeal lies under 9(6), that we will be answering. But this question has to be dealt with, because in the facts of that case, this question did not arise. So we did not decide. That you can't argue. Like this is in his case, when depending upon, so you, madam, you understood 2 instructions on 2 aspects, right? 2 aspects, whether same members have heard his appeal also, that is one aspect. Second issue is about that order by which he has, you can argue that an appeal lies, not doesn't lie, whatever he will argue, we don't. That we will hear you at 2:30, seek instructions on that. And on this factual aspect also, whether the board has passed an order or as he has contended, the president has passed an order or the board has passed. What statement will be, we will have to.
The order says.
Oh, no, but there must be provision, right? No. You can say, that no deficiency on account of vacancy in the. No. Normally, it's given. What is called Ganga clause, right? In all other enactments, it's there. Oh. Find out, madam. 30. You will be able to seek instructions. Okay. Impact. Yes.
Finally, number 24. Again, more.
Tomorrow. It will be repeated.
25.
55. Oh, nobody is opposing, right? You have a good case. Nobody is appearing to oppose you. Very good opportunity. What is it? Wife technique. What happened? On the ground of dual desertion.
Kalini, kind of color, with something. So, you will operate in it.
Did not find any objection. What can be done? Then, what is it? Have you filed a complaint before bar council? District council? You not the ground, right? Evidence. You are served with the, you did not leave any evidence. You point out that from evidence, no ground is made out. You decide. So when marriage took place,
On Mela.
1860.
And
When did you leave?
you.
What is the environment? Environment.
So that 5 months. 5 months. 3 years. Okay. Society.
Deputy matrimonial.
Yes.
After 5 months.
Yes.
Okay. The petition.
Filed on 29/10/2014.
Is
3 years.
parking behavior, written evidence is required to discharge. Yes. So now 18/6/2010 marriage took place. Then after the para 5, it is said in the petition that within 5 months of marriage, you left the matrimonial home. And para 8, what means uncontroverted evidence, mister, you have not even cross-examined. We are just trying to tell you that the grounds of desertion on the pleadings are made out and the evidence adduced. Go ahead, what is this? Please. Not correct means what? So you are saying that finding is not correct, that you have deserted, right? What is?
9, 11, it's a 91.
Yeah.
Yes, after confinement period, she came back to the woman.
Ah.
In the year 2014, it went to mother-in-law, her-in-law, will be a home.
Can't take it like this. What you are required to do in case you want. Should have filed it along with an application, whatever. It can't be photocopy like this passed on it. This is appeal.
P3 notice. 5 months. Yes.
Matrimonial. It is dated.
Is dated 2/9/2014. P3.
Or
Highly recommended. Yes. Continue after the break.
Court officer. Court officer,
Sir? Sir, serial number 11 ಏನಾಯ್ತು? Sir? Sir?
that's going on. Like the education. We take it later.
Number 9.
Is your challenge to this refusing to grant permission.
Good. Kindly come. 117.
This is an order passed under which provision?
117 will be, there is no provision for such an order.
There application under which you are granted conditional permission. That is Mr. Regulation 3.3 of the regulation.
So that is his. Conditional permission. Here. This order is passed by the.
No, we have understood your challenge to these orders, right? First, the order passed imposing you penalty of 2.7 crores and order
Yes.
upheld in appeal. They are asking you now what ground you are challenging this order dated 17.3.
The order. Order is passed by the. In this one,
Order is passed by.
but by the president of the board. If your lordship kindly comes to 120, page 180. Reviewed order starts at 117. 120, if your lordship comes, my lord.
Yes.
Please come to para 8 there. Para 8, para 9 in the bottom. Therefore, in view of this. Therefore, in view of the above shortcoming mentioned above, it has been decided by the president. Medical assessment and rating board for Indian system of medicine to issue the conditional permission to also under section 8. The hearing, the lordships will get at para 4 at page 80. Also, 4 at 80. It was by a hearing. At page 100. Refer back to the same inspection.
Oh, so hearing committee and order is been suspended. Same law.
Same. There was a hearing committee here. See, but the board is defined as that. Who the board? Comes to the act alone. Okay. 18(1)(c) is medical assessment and rating. Then the words 19(c), 19(1)(c), if you lord. The medical assessment and rating board for Indian system of medicine shall consist of president and 8 members. And provided that the president and 6 out of 8 members shall be chosen from Ayurveda, Siddha, Sauvya, Ripa, Unani disciples of Indian system of medicine in such manner that at least 1 member represents each such discipline separately, and the remaining 2 members shall be accredited. In other words, it's submitted that in this case only the president passes, not the board. And also, this
Where do we get it? President has.
that's what I read that page 120. 120 para 9. The last clause at clause 9 at page 150. Bottom. Therefore, in view of the shortcoming mentioned above, it has been decided by the President Medical Assessment and Rating Board for Indian system to issue denial of conditional under section 28 of the NCISM Act. Under 28, the President takes a call. The board notes saving clause. There is a saving clause for the commission. When it comes to section 9, the Lordship wanted to saving clause.
Commission.
Section 9, if your Lordship see, 9(5). Only for the commission it is provided, not for the board. Page 6, section 9, 5, subsection 5. It's only for the commission.
We need not decide that issue.
Right?
We need not decide this issue. I mean,
If
you
it
are,
is-
you are, this thing ground of challenge is again confined to this order only on two grounds. That it is heard by one authority, order is passed by the other. And the order in this case has been passed by the president, whereas president as well as 8 members of the board have to take a decision.
It should be a board. Application to the board. Section 28 does not cover quite different. Over to the board to delegate its powers. If you know,
Question.
section 28,
What about section? There is some provision, section
25, your lordship may kindly see 25 is the delegation. I think commission can delegate its powers to the fully administrative and financial. 25(1). The commission may delegate all or any of its administrative and financial powers to the president of each autonomous board to enable such board to function to gain efficiently. Now, please see 2 members. Section 2 there. The president of an autonomous board member or officer of that. So, but 1 and 2 has to be read together because the word used is after. What powers commission delegates to the president? He has the powers to delegate that power. These are not the word of the CIM will tell you. These are positive decisions. Order others to my interest. It's a contribution, so there is a not a.
Where the ground taken by you that order has not been passed by the board, but only president.
And that's the. After amendment, it is not been. That ground is very one. After amendment is 56 A and 56 B and C. That particular ground. Not only that. But if it's a question of law, I will request my lords to consider that aspect. Or come out in the grounds. That delegation, there is no such power. What is permitted is only under 24. Commission can delegate. Board cannot delegate. Commission delegates itself. He can in turn delegate, but not such of the power that somebody else has to pass a order. Please visualize a situation. Suppose that the hearing committee recommends that approval should be given or penalty should be paid. Then can the board will not take a contrary stand? Say that we overrule the hearing committees, it becomes a.
It has to be remitted. Right. What about this order? We will again. Thank you. Sir, as we passed by the board, right? Please see. What does it say? Whatever. We are not going into that question, but what does it say? Please see the order. We are only going on this. Para 9.
Page
Para
120.
9, para 9, page 120. President decides Right, that is not a typographical mistake, right? And no, para 9 means, no, therefore, if if his signature would have appeared, we could have held that he has signed on behalf of the board and would have asked you to produce it. But read para 9, he says, I am passing this order. Therefore, in view of shortcoming, it has been decided by the President Medical Board. You can't, I mean, it has to be considered by the board.
Even in the signature also, it is written as president's also. Signing.
So we have dictated the facts during the. So we will continue.
For us.
No, but I mean, it is being objected to. That's what I felt surprised. So we have now changed. Everything is being dictated here only. So for your benefit, for benefit of both of you, facts up to para 7 have been dictated, and I'm continuing beyond this, right? So that operative portion is dictated in your presence. I don't think you demand that facts also should be dictated in my presence.
For us. Okay, they could be over.
No, this was in fact to hear more cases. It's a good situation for us that half an hour will be gone now. So in this we could have heard other cases, but it's all right, fine. Yes, learned senior, fine. Huh?
Because of their fault, I have.
All right, learned senior. Wait. Yes, learned senior para 8. Learned senior counsel for the college further submitted that the order dated 17/3/2023 passed by the commission, by which conditional permission under section 28 of the Act for admission for intake capacity of 60 seats in BAMS course for academic session 2022-23 has been denied. Also suffers from an infirmity in as much as opportunity of hearing has been granted by the hearing committee, whereas the order has been passed by the president of the board. Learned senior counsel for the petitioner, learned senior counsel for the our attention, delete. Our attention has also been invited to section 19(1)(c) of the Act, and it has been contended that the board is required to pass an order under section 28 of the Act, whereas the same has been passed by the president. And therefore, the order dated 17/3/2023 cannot be sustained in the eye of law. On the other hand, learned counsel for respondent number 1 and 2. 2 and 3. 2 and 3 has fairly submitted that the appeal has been heard, that the appeal preferred by the college against the order dated 1/2/2023 has been heard by a committee of 2 members, namely Dr. Suryakant Wage and Dr. Haridra Dea, and on the basis of their recommendations, the impugned order dated 1/2/23 has been passed. Impugned order dated 6/3/23 has been passed. It is, however, submitted that the order dated 17/3/2023 has been passed by the board, by the president on behalf of the board, right? On behalf of the board, paragraph. We have considered the rival submissions made on both sides and have perused the records. Section. Thank you. Section 19, Chapter 5. Chapter 5 of the Act deals with autonomous boards. We have considered the submissions, rival submissions made and have perused the record. Then right, before proceeding further, it is apposite to take note of the relevant statutory provision. Section 19, Chapter 5 of the Act deals with autonomous boards. Full stop. Section 19 deals with composition of autonomous boards. Full stop. Section 19(1)(c), which is relevant for the purposes of controversy involved in this petition, reads as under quote. 19(1), composition of autonomous board shall be as under C. That we will keep it open. Not necessary. Right. 19(1)(c), right? Quote. Paragraph. Thus, line below. Thus, it is evident that the board consists of president and 8 members. Yes. Also not in dispute that an order under section 28 or an order under regulation 3(3) of the regulations, whatever regulation, in other case, regulations 2016 has to be passed by the board. Which the instant case, comma, admittedly, the decision, admittedly, comma, after inspection of the premises of the college, a notice dated 19/12/2022 was issued to the petitioner, to the college. Full stop. The college was asked to appear before the designated hearing committee on 23/12/2022. Full stop. The aforesaid designated committee consisted of 2 members, namely Dr. Suryakant Wage and Dr. Haridra Deya. Full stop. The committee, full stop. The aforesaid committee, after hearing the college, made recommendations which were discussed by the board in its meeting held on 29/1/2023, and thereafter an order dated 1/2/2023 was passed imposing the penalty of rupees 2.75 crores on the college under section 28 within bracket F of the Act. Full stop. The college preferred an appeal. The appeal preferred by the college was again heard by a hearing committee comprising of aforesaid 2 members, namely Dr. Suryakant Wage and Dr. Haridra Deya. Full stop. Haridra Deya, who had already made a recommendation against the college. Full stop. It is not in dispute that on the basis of recommendations made by the hearing committee comprising of the aforesaid two officers, the president of the board, by an order dated 6/3/2023, dismissed the appeal. Full stop. Thus, the decision-making process clearly suffered from the vice of bias, and the order was passed by the appellate authority in violation of principles of natural justice. Full stop. Paragraph. For the aforementioned reasons, full stop. That's all. Bias. And therefore, the same cannot be sustained in the eye of law. Paragraph. As is stated, comma, the board comprises of president and 8 members. Full stop. However, in the instant case, comma, the impugned order dated 17/3/2023, by which conditional permission was denied to the college, was passed by the president of the board alone. It is evident from paragraph 9 of the order, which is extracted below for the facility of reference. Quote, page 120. Para 9. Thus the order, which is admittedly required to be passed by the board, thus the order denying conditional permission, which is required to be passed admittedly by the board, has been passed by the president of the board alone. Therefore, the same also cannot be sustained in the eye of law. Paragraph. For the aforementioned reasons, impugned order dated 6/3/2022, passed by the commission, as well as order dated 17/3/2023, passed by the board, denying conditional permission to the college for admission for intake capacity of 60 students to BAMS course for academic session 2022-23 are hereby quashed. Full stop. The commission is directed to decide the appeal referred. Your appeal will be decided by the commission, right?
Yes.
The appeal preferred by the college against the order dated 1/2/2023 shall be decided by the commission afresh after affording an opportunity of hearing to the petitioner within a period of 4 weeks. Full stop. The board, full stop. In addition, the board is directed to decide the issue pertaining to grant of conditional permission to the college within an outer limit of 2 weeks from today. It admission, it pertains to admission. We don't know. We are not, since it's the order is being quashed, that's why we are asking you to take a decision within a period of 2 weeks. In addition, the board shall also consider in case the college is able to satisfy the board that the deficiencies do not exist, the board shall also pass an order, shall pass appropriate orders lying below. Accordingly, with the aforesaid directions, the writ petition is disposed of. Right. Appeal. Yes. That issue we are, and say needless to take that all issues are kept you say needless to state that all issues are kept open to be agitated at are open to the parties to be agitated in an appropriate post. We need not go into that question of hearing by one body and this thing, because if we are remitting.
This-
25. KSC.
No, no, not. Keep it, Mr. I keep this also. Take after. Yes. Yes. Ah, thrown out on 25/7. Opportunity provided you are not served with the notice. What will we do? Explanation why the council did not file a statement of office. Council doesn't mean that he's above law and immunity from just whatever he can do. He likes. Have you? We are asking you. Have you filed a complaint against your council? What? A rustic villager. What to then? She has to thank for engaging a council who didn't fight. What can be done? How do we set aside the decree? Tell us what ground. What will be right? No, we could have set aside, supposing if you would have said that notice was not served on me, we would have set aside. We have to, this is a decree in favor of respondent. We have to set aside for a cogent reason. What reason? Opportunity. The effect of non-examination of a witness to law. If you don't cross-examine a witness, what is, we have to give effect to law, Mister. We can't, that's what we are telling you. If you don't appear, don't file statement of objection, don't cross-examine, whatever he says, he will be taken to be correct. What is wrong? No case, unfortunately. What to do? We are helpless. This appeal. That's all. Anything else? Like what ground? Tell us what ground we. That's why we asked you in the beginning also. Again, we are asking what ground we can remand. Tell us. What ground? So you have not said anything that you have taken an action against your counsel, nothing. Who will believe that you had, why should we infer against the counsel? Why he would not fight? Yes. This appeal. Section. It's appeal under section 19 within bracket 1 of the Family Courts Act 1984 has been filed against judgment and decree dated 18th of April 2016 passed by the Family Court, by which petition filed by the respondent stroke husband under section 13 like the petition filed has been allowed and the marriage between the parties has been by decree of divorce. Paragraph facts giving this appeal stated strictly stated are that the marriage between the parties was on 18/6/2010. Thereafter, the lived in their matrimonial home, and and on 9/6/2011, a son was born. The son was born to the appellant. Paragraph. The respondent stroke husband filed a petition on or about 29/10/2014 inter alia on the ground that after 5 months of marriage, the appellant stroke wife left the matrimonial home and matrimonial home, full stop. It was in paragraph 3, in paragraph 5 and 8 of the petition, it was stated that the parties are living separately for a continuous period of 2 years, 3 years, immediately preceding the date of presentation of the petition. Stop. It was also pleaded that the respondent spoke sent a notice dated 2/9/2014 within bracket exhibit P3 asking the appellant stroke wife to give consent for divorce. However, the appellant stroke wife neither responded to the aforesaid, did not respond to the aforesaid notice. Full stop. Accordingly, degree of dissolution was sought on the ground of desertion. Paragraph. The appellant stroke wife admittedly was served with the notice of the proceeding and engaged a lawyer, engaged a counsel. However, neither any statement of either any statement of any statement of objection was filed on behalf of the appellant stroke wife, nor any evidence was adduced. Full stop. Paragraph. The appellant, the respondent stroke husband, in order to prove his case, examined himself and exhibited the exhibit P1 to P7. Full stop. The family court, while judgment dated 18th of April 2016, Australia held that 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 the uncontroverted that controverted that the averments made on behalf of the respondents to as well as in his evidence would have not been controverted on behalf of appellant stroke wife. It was further held that uncontroverted allegations made on behalf of respondent stroke husband constitute a ground of desertion. Section 13(1)(e) of the 1A of the Hindu Marriage Act granted the degree of divorce. Full stop. In the aforesaid factual background, learned counsel for the appellant, learned counsel for the appellant submitted that the appellant stroke wife was thrown out of the matrimonial home on 25/7/2014, and thereafter the appellant filed lodged a complaint against the respondent. It is further submitted that police also advised the respondent, however, notwithstanding the advice tendered by the police, the respondent stroke husband did appellant to join the matrimonial home. It is further submitted that the matter be remitted to the family court and the appellant stroke wife be granted opportunity to adduce evidence. Paragraph. We have considered the submissions we are made by learned counsel for the appellant and have perused the report. Admittedly, the appellant stroke wife was served with the notice of the proceeding and had engaged a counsel. Full stop. The counsel participated in the proceeding before the family court. However, neither any statement of counsel nor any evidence was tendered on behalf of the appellant stroke wife. Full stop. It is strike law that if other side, his testimony is deemed to have been accepted. Full stop. The absence of any rebuttal, in the petition, rebuttal of the averments made in the petition under section 13 of the act, as well as uh, as well as uh, the fact that this respondent stroke husband was not subject of examination, the family court has rightly concluded that the appellant stroke wife has deserted the husband for a continuous period of 2 years immediately preceding the publication of the ground for death as due to be the finding recorded by the family court does not suffer from any infirmity warranting interference of this court. This for the aforementioned reasons, do not find this appeal is fine.
Yeah, then.
Case 26. Yes. Yes. So, we had suggested for
That we have suggested on that day what has transpired. I think that is the reason we have recorded in order to see that.
You were called in the chamber for. You said that you would amicably settle
This.
coming. Hey, we had asked you to both the count. You were there, right? We had told you to discuss, right? You are discussing the court again, same thing. Hey, we are not going to negotiate, right? He is not our child. If we told you on that day, called you in chamber, said that please settle, you agreed, both of you.
No, he isn't. He is in 10th standard. I think, no? 9th standard. For 2 years. It was the same kind, instead of. Say,
So what happened to that, Mr. Your colleague had come on the last date of hearing when we interacted with the son. He said that we will find out an amicable settlement. There's no problem in writing the judgment right away in your presence, right? No. We are only asking whether, since it's a human problem, your son is studying 9th standard all along. He has been with your this thing, these maternal uncle and aunt. You should consider. If you don't want to, we will pass an order right away. Just give that judgment. Section 25. That.
and that you are staying in Shimoga. Sir, you are alone. Already child is there from so many years. We know that, but and this last 2 years, shifting him from Davangere and nobody is disputing your relation and all those things as a father.
They are also not disputing that you are the father. He is not saying I am the father. All right, please. So we will have to hear him, right? This is what we have been telling on that day also in chambers. We said
Maximum visitation rights, if whatever we want to discuss with him.
Mr. Advise your client properly. It is in his interest that an interest of the child. He should not be emotionally uprooted at this stage. We understand, but he is not being tortured at his parents' place, right? His maternal uncle. This is not your case that he is being tortured, not being friendly. So that's they are taking care all along from when he was a young boy. All along they have been this thing when he was 2-3 months old. They have taken care. Right? No. We are telling you that these are the factors which you take into account and advise your client. We told you, argue right now, you will get the judgment today itself. There's no difficulty, right? We are not seeking an adjournment. On that day, we advise you. Why this thing is that it's a human problem. If you agree, fine. Otherwise, if you want to litigate, go. Since you are saying that you want a week's time, that's why we are telling you all this, that you should consider and advise your client accordingly. All along, your son has been with his maternal uncle and aunt, right? He has been taken care of like a son when he was 2 months old.
After 7 years, you have filed the petition.
Please argue then. Please, we are not preventing you. Please argue. We are not forcing any compromise. We are not forcing any compromise. Much we have granted you for time for this very purpose, right? To ascertain the possibility of amicable settlement. Yes. Learned counsel for the part. Once again, jointly pray for adjournment to ascertain the possibility of an amicable settlement of the dispute. In view of opposite submission by way of indulgence, hearing is deferred list after 2 weeks. This is Today is the date. We are ready to hear today also. You are saying it has to suit you. Tell us any date after 2 weeks. Huh? List on 10th of, instead of 2 weeks, list on 10th of April 23. Keep this.
Okay. That's
28 no office. No.
$28.2.
Huh. Huh. Is praying for adjournment. What do you say? So are you opposing the prayer for adjournment? It will be put up. It's their job of the office, right? You can't ask everything for the court. Tomorrow you will say, go to the filing counter, bring my mem. Not like this. It is their job, they will do it. If it's not brought, we will summon it. He will do it. No.
That's not it. We'll look into.
So, yes, Mr. Next week, Learned Counsel for the appellant prays for a short accommodation to enable him to prepare the case and the same list next week.
about 29. MS Bhattacharjee in Narayangarh. Yes, Nayak. Okay.
He is appearing for the appellant. Here, sitting here.
So,
Next week. Not for the appellant. Students, Learned Counsel for respondent number. This Narayan Bhatt Learned Counsel for respondent 4. And government advocate for 1 to 3 and Mr. Bhatt for respondent 4. Awaiting appearance of Learned Counsel for the appellant, hearing is deferred. List next week.
okay. Is available.
think. Is 23 1D. Hindu marriage act. Was not even brought the book. That's why you are arguing like this, that there's nothing like delay and all this. Eat the provision matter. Arguing a matter for final hearing in the High Court without bringing the bare act, jumping to conclusions without telling us the facts. Nothing. No, read. I mean, read clause D. D is sufficient. No, D. 23 1D. So what did you do for your wife left in the year 2005? So when did you file the petition? Tell us when. When, according to you, what date she left the matrimonial? Date.
October 2005, she from that day onwards, without informing anybody, she left the house. And again,
What did you do when you filed a petition in the section 9?
I did it in 2009. But I was taking consistent efforts.
1 2015. 2015.
But I thought
These facts have to be pleaded before the family court, not in memo of appeal. Where have you said in your evidence or in the petition under section 13? Where? Which paragraph?
Para 11.
Petition. These facts have to be pleaded before family court or not, that there is no date. We are not clear to you. We have said that you are saying your wife deserted you in 2005, right? Thereafter, you have filed the petition when
2009.
I have fight for.
Madam,
where
kindly.
are those facts pleaded, madam? Simple this thing. Both facts have to be pleaded before family court or in member of appeal. So we are asking simple question to you, which paragraph of the petition you have explained that this is the delay, this is how it has happened. I had filed the petition under section 9, I was prosecuting it. Then this order was passed, thereafter I gave a notice, then filed a petition. That's what we are asking. Please tell us which paragraph of the petition.
Yes, yes. Two thousand nine, sir. Did not contest. After C has filed a DV case. It is not. Yes.
No, madam. You should have seen the record, right? You are sitting here since morning, you could have seen the lunch break.
Para 11.
What happened to the petition under section 9? Tell us. Why did you file the petition? You have to explain the delay. You are saying no delay. You have to explain. Otherwise, you have read 23(1)(d).
Otherwise, 4 years delay. That is. That you can't explain. It should come out from the pleading. No?
But what
Right,
happened
but
to your petition?
you're not challenging that.
No, you said,
appeal.
madam, you said 2009, you filed a petition under section 9. We are asking what happened to and when? Where have you said? Which paragraph of the petition? When it was dismissed?
Not made any effort, effort for restoration of that decision. Yes. 3 points, sir, I'll pass on. Yes.
Like a storytelling competition, madam. This is an appeal. Right? You are not reading. We are asking you, where have you pleaded? Where have you explained the delay? You are just telling without you have our record. You are not reading it. Just storytelling. Please read. We are asking you what. Please read.
Family year in case they number 1872. They also may not the petition right for reconciliation, but respond of the House to you, I mean, right? Why you let it out? He wanted to see the child. I go, okay, wanted to see the child, you go. Then when she tried for the that time he never
Yes. Yes, sir.
This is all oral submission, nothing on record. This is all oral. This is what you are saying. Can't pass on documents like this in an appeal matter. RUT case just. What is this? So we should bring to your notice and then you will, no, sorry, madam. No, we will not, this thing. You cannot say like this. We should perhaps record your submission. That the court, that the council is saying that we have brought. No. Okay. This is highly objectionable. No. Okay. This is Srimati Sandhya Jamdagni, Learned Counsel for the appellant, must hear correspondence. Arguments heard, cases reserved for the review. Give the record back. Much, madam. There is something limit to everything that the court should bring to your notice. What are the that you have not filed documents, and then you will seek adjournment. Too much. No, 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 no. We have just now argued. We did not ask you. You started arguing the case. You should have sought an adjournment in the beginning. This is not done. No, no, upon. No, no, hoping that the court will grant decree. That's why. It's not. No, no. You have argued the case. If you want to say anything else, we will hear you. Please go ahead. If you want to argue anything else. Yes.
That is well said, madam. Madam,
That you-
asking question itself, you take that and start taking adjournment, it will be difficult for any judge to work.
Then you want
To
that the
express
court
our
should
mind.
not interact with you, should not put any question. That's what, I mean, supposing if we ask any question, that will be a ground for seeking adjournment.
You
No,
conclude.
no, I mean, it is, no, madam, please, I mean, think about what, think what you have said, that the court has brought to my notice. It's your case or our case. So that you have argued the case. If you want to say anything, please say. We will hear you. Please argue. Anything else? Otherwise, it is nothing. Not after having argued the case. We will reject it. Not after having argued the case finally. Nobody compelled you to argue. You started arguing. And we have put a question simply. So you are now seeking adjournment. Is this the... No, sorry. We can't grant it. No. Apology. There's no question of apology. No, madam. We are trying to decide the case in accordance with law. Nothing else. We don't have any animus against your client, right? We don't know him. We don't know him, your client. Nothing. Sorry. No, nothing. Madam, you are not in a market bargaining and we are not selling any product to you. This is please, for God's sake, this is High Court. Don't bargain. We have given you an opportunity. Please, if you want to argue anything, we will hear you. Otherwise, it is reserved for judgment. You argue if you want to say anything. Don't bargain. We are not selling any product to you sitting here. You want to say anything? We are ready to hear. Why did you not say in the beginning then? Good. So then thank yourself. Didn't realize. Thank yourself. Yes. Next case.
31, Group of 28, YSH 20.
Yes. That's right. We will adjourn. No problem. Learned counsel for the appellate. Praise for adjourn.
Do that.
Huh?
Do that. We are adjourning next week. You please report the settlement. If you
Yeah.
are settled. 2 weeks.
Learned. Learned counsel for the appellant. Praise for adjournment. Enable him to prepare the case and argue the same list after 2 weeks.
32. Chapter 5.
What there? Passover. It's not there. Passover. Otherwise, the review petition will be recalling application. Order has been passed in violation of natural justice. Counsel has not been heard. He was unwell. You know that, right?
Yes.
Learned counsel for the appellant prays for adjournment to enable him to prepare the case and argue the same list next week. Who appears for this? Sure. Ready? Huh? She has come. Yes, madam, ready? Noticed by the court and.
She is regularly in family. Not 23.
And So the learned single judge has held that order has been passed without notice to the petitioners. Not correct. They have been heard.
Yeah. Yeah, yeah. Just order along with an idea for district documents. Very.
Yes. Contesting respondents, they are not nobody is appearing. Okay. Yes.
Credits of the review order separately was further grant the limit as to order.
Yeah, okay.
The review is arising out of this order.
Then this rendered, this question is rendered academic, right?
Oh my lord, see. Succeeding the result.
What she says. Pursuant to, just a minute. This is, this order is passed on 22nd January. So, yes,
Serial number 17.
yes, allowed. Right. 29th April, order was passed by the. 266.
Specific aspect on this point. First, by virtue of this order is repeated at 22.5. Jurisdiction to excise revenue, the to hear on the review application was permitted. Which, if this order is not. If this review petition.
This means you have filed a writ petition, right?
Here, whether the Lawrence is the question. Apart from that bylaws, there are multiple owners. In respect of the review application, we are trying to solve the owners. But in the review application, even other owners' rights are granted. That is a subject matter of writ petition. In this writ petition, one owner was key person who had filed the writ petition. When this matter was sent back to review, owners 2 and 3 have also prepared separate application, in respect of which also there is some pending interest granted. Also, the subject matter of the writ petition says that not have been considered. But if I were to succeed in the writ application, it's not exciting. Automatically my
Will allow your writ petition here in writ appeal. That's the effect, right?
I was of course the issue is what there.
Side, Mr. 4 o'clock, we are entitled to say one sentence. You want us to allow your writ petition in this writ appeal. Yes. That ground you can take in the writ petition also, right? We'll
Question
grant
of
you
law.
that liberty.
The question of law, you can urge, we can
Grant you
clarify
the
that. We'll just clarify
It
saying
will
that.
be open for you to
Uh-huh.
raise a question of
Review.
maintainability of the
Review
review in the writ petition. That will serve the purpose.
Firstly, you can cover there all the issues. It's only
For that, you will have to, can't do that.
jurisdiction window.
You will have to move the registrar judicial. Do that.
Because actually, the challenge is on mirror limits.
What prejudice do you suffer if we say that it will be open for you to agitate the issue of maintainability of the review petition also? You will say so. That's the only thing, right?
Yes.
Why to keep it pending?
Or in the process, if some finding is given, you should not be affect you there. By take.
If you are whether review itself or proper or not,
You can have-
actually itself can be added, submitted, we have to then it is definitely not this find your proper.
That's what we are saying. Yes. We need not examine this issue. Yes. The court appeal has been filed by the appellant against dated 22nd January. Citra Court appeal has been filed by the appellant against order dated 22nd January 2014, passed by learned single judge, by which the order dated 31/10/2011 passed by the land tribunal has been quashed, and the land tribunal was directed to decide the application referred by the petitioners in the writ petition seeking review of the order paragraph. Admittedly, in pursuance of the order passed by the learned single judge, the land tribunal by an order dated 29/4/2015 has decided the review petition. Has decided the review petition. It is also not in review petition. The tribunal has decided the review petition by an order dated 29/4/2015 and has issued a corrigendum on 13/4/2016. Full stop. It is admittedly against the aforesaid orders, the appellants have filed a writ petition, namely WP number 26626/2018. Paragraph. After hearing learned counsel for the parties, we deem it appropriate to grant the liberty to the appellant maintainability of the review petition before the land tribunal at the instance of the petitioners in WP number 4347394/2011. Needless to state that in case such a contention is raised, learned single judge shall and the aforesaid liberty below with the aforesaid liberty, the appeal is Mr. Yes, Mr. Yes, Mr. Patel. Other respondents are not present. 5 and 6, Mr. Reddy and all.
8 hours.
8 also. So shall we take it up tomorrow? But it will be repeated. Go up here. A testing respondent. Ready? Yes. On filing of details of any other litigation. What happened to criminal case? Still pending.
We conduct cases will have to sort by a lordship.
Where is this ILR 2003? That you have filed it today, one copy you have annexed it, you could have annexed it here, right? Oh, before filing different this thing compilation, making our life difficult, right? Yes, Mr. Well, case you have been acquitted. Well, case, you said you have said it's pending. That we understand. Another before Lokayuk. Pendency of cases on this date. You have not mentioned that he has been acquitted by criminal court. Well, acquitted by criminal court in a criminal case.
Special CC 100 of 2012. 6th December 2018. Against this appeal, criminal appeal is filed by Lokayukta.
This is not here, right? Have you mentioned this fact in your
Synopsis does not mention.
list of relevant dates and events? It's not there. It's relevant, right? You have mentioned that he has been acquitted and appeal is pending. Huh? Go where it is mentioned, not only list of dates. You have given us future options. We are looking at it. Now you go to ground number 7. Fair, right? You are a young man. That's why we are telling you. First duty you who is to be fair to the. Then comes the case and its result. First duty. First duty. What would have happened if you would have written that he has been acquitted and we have filed an appeal which is pending? You have mentioned everything, given judgment, everything, all this synopsis, and that date is missing. Look, we hope that we have been able to convey the whatever we wanted to tell you. What always remember, first duty is to be fair to the court. After the case and its result. That's what we are saying, nothing beyond that. You be cautious henceforth, because we rely on you. We were surprised when he told that he has been acquitted. It's not there. We were thinking that it's pending. Would have said, nonetheless, it's pending. Yes, yes, Mr. Acquitted. 30th. There is a regulation 172 and 170. Yes. Yes. It is all, it's not that simple, comma, comma, full stop, and so it's all disjunctive also. Please read it again. You read along with comma, then you will get it. Board further reserves a pension, comma. And now this is disjunctive, right? And so that withholding, withdrawing, and right of ordering the recovery. These are three rights. If in a departmental or judicial proceeding. Service. Yes. There are decisions of it's covered. Very material provision has been dealt with, we are sure, in several and some of the decisions of Supreme. Have you got it? How we will hear? Yes. So you say that only in case of a pecuniary loss they can recover, withhold. And in criminal case, you will be asked to undergo imprisonment. So therefore, there is no justification for withholding. What happens to this judgment? Have you gone through? Judgment relying upon the judgment, have you seen? GN Gunte, ILR 2003 Karnataka 3851. Huh? Right. Page 64. What you are paying the provisional pension at the rate of 75%. What happens to this? See this also. 172.1. Please see. Then, then you are not at this. See this provision also. It clearly says that you are entitled to a provisional pension during the pendency of either. Then doesn't say so. Where the departmental or judicial proceeding regulation once a department is continued under clause A2 of the proviso. Please see tomorrow. Please. Thank you. They appear normally. Yes. Yes. Who appears? We will reflect his name. Please tell. Akshit. Reflect his name. Right.
It appears he has made a statement that respondent is also not well. He is in ICU. Same case.
Some days looking after, that is not the appellant's. He is looking after the father. Nobody is there. Not the father. So, he is hospitalized.
Killing.
Yes.
Killing his husband.
Your appellant's husband, that is respond.
You are husband or wife? Acha. Right. So husband is hospitalized.
Yes.
You have to take a call. What he probably was telling us yesterday that you are taking care of the husband, right?
Son. I'm ready to.
To do, nobody appears for respondent.
Yes, but I asked him. The reason not go for this. Two things not.
Yes. Fine. Mr. S.V. Prakash, let me come for the appellant is stated. None for respondent. It is stated at the bar that Mr. P.N. Raghupati, learned counsel who represented the respondent, has left practice, right? In view of questions of court notice for his appearance before the court on May after the opening there. 25th May 23.
37. ED Ravi. Statement sheet.
Right. Yeah. He has also to say like that, no? That there is a we can't, if unilaterally you say that there is a possibility, it won't help. We'll call it tomorrow. Maybe it's now nearing 4:30, so he's
38. Banana easy.
What do you want? Next week. Learned Council, 38 Learned Council for joint parties jointly going for adjournment is next week.
29. Rajesh Shetty garu, don't celebrate.
Yes, madam. Ready? Yes. Huh? We thought you are smiling, you are ready with the matter. Huh? Yes, Mr. Then it's repeated tomorrow then. Yes. I will. Asking to be there, madam.
Responded.
AMCPC, it has come. Yeah.
Action will not to find a treating with the the was rejected by the report, holding that such application is not maintainable under section 1. Petition was filed challenging the order passed by the executive court and invoking the supervisory jurisdiction. Disposing of that particular petition, the learned single judge exercised the original jurisdiction also, as well as the supervisory. Exercising the original jurisdiction. Application is that, my lord, I was not party to the application. It was filed before the executive. Executing court has no jurisdiction to decide that particular application as per section 47 of the CPC. As per section 47 of the CPC, my lord, dispute are a decree. This particular dispute, which was before the executing court as well as the decree, which the executive court rightly held that one cannot decide that particular application, and the other remedies are available. That particular order came to be challenged before the learned single judge allowed the writ petition and issued the direction. What was sought in the original application which was filed. That, my lord. On the point, my lord, whether the court is responsible or the registry is responsible for the inaction, who has to pay the amount is one aspect. The question is that whether I was a party to the proceedings, whether I had an opportunity party to the proceedings. I request my lords to kindly take. Section 3, page number 70. Where we sat. That for the reasons spoken to in the accompanying the auction procedure says that the honorable court will use to direct the office of the honorable. Pay a sum of rupees towards the interest on the deposit amount of rupees. The interest of justifying. I was not party to this application. And this particular application would not have been filed before the Order my lord to find a page. I think I can find my lord to find page number 89, page number 10. Paragraph 59. Further for particular order was challenged in the repetition. The request was I take the lead. Page number 24. Page number 26 is the concept. First time I was made. Not for my lord to find at page number 23. Page number 33. With respect of the order passed by the court, my lord. From this prayer, it is very clear, my lord, supervisor jurisdiction of further input.
What basis he is seeking interest on this amount?
There was an order passed by the and one particular point. What is the remedy available to the person? He has a remedy, two remedy. Either he has to file a proper suit, my lord, and he has to seek a relief against the person who has not followed the directions. The other the district has to pass a either he can seek for special or he can seek for final. They have the option to file an application. Application is not made. I was not made. I was not part of the. And whether section 1 application is maintained. The submission is that under section 47 of 6. What says that anything arising, any question arising out of any passed by the court relating to the degree, that is my one first. I put in that it has no jurisdiction and the application of section 151 is not made. But application is that my order. And jurisdiction is vested if that jurisdiction is not right in such an event by not such jurisdictional error can be. Here it is not so. And learned single judge by lord has issued this particular direction because my lord to kindly take the operation of the court. The relevant order starts at page number 15.
Continue tomorrow. Yes. Yes, for further hearing. Who appear for the appellate is praying for any objection. 44 next week, Mr. Learned, mark the presence, learned counsel for respondent prays for judgment list in the next week. Next week. Go for the petitioner. Yes. 52 learned counsel for the petitioner prays for shorter completion placed in the next.
ನಾಳೆ ಪಕ್ಕ ಹೇಳಿದ್ನವ ನಾಳೆ ಗುರುವಾರ ಅಲ್ಲ.